Namaste. Hello friends. Today in front of us we have on the editorial page from the Indian Express. The title of the article is Human Rights and Wrongs. It is written by Prakash Singh, who is a retired police person. Let's read the article. Human Rights and Wrongs. A study on torture by police brings out disturbing patterns. We need a law against use of these methods. Common Cause. A reputed NGO in collaboration with the Lokniti program of the Center for the Study of Developing Societies CSDS released a comprehensive report on the police torture and unaccountability on March 26th. It explores the nature, causes, and factors that contribute to the perpetuation of police violence and torture in India. The study is based on interactions with 8,276 police personnel of different ranks across 17 states and union territories. The findings bring out some very disturbing features. Some redeeming features. There are, however, some redeeming features as well. Torture has been defined in the UN Convention of 1984 as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent of acquiescence of the public official or other person acting in the official capacity. So this is the definition of torture given in the 1984's UN UN Convention. India signed the UN Convention Against Torture (UNCAT) (UNCAT) in 1997 but has not ratified it, which means it is not legally binding on India. The report brings out that 20% of the police personnel feel that it is very important for the police to use tough methods to create a fear amongst the public, and other 35% think that it is somewhat important. In other words, 55% of the police personnel favor tough methods to some degree. Significantly, they have not talked of torture. What these tough methods are and at what stage they assume the dimension of torture have not been clarified in the report. In cases involving sexual harassment and child lifting, 1 in 4 police personnel justify mob violence, implying that they do not mind mobs acting as the judge, jury, and executioner in such cases. Another disturbing finding is that 22% of the police personnel believe that killing dangerous criminals is better than giving them a legal trial. But it is also a fact that 74% police personnel are of the view that no matter how dangerous a criminal is, the police should try to catch them and try to follow a proper legal procedures. In matters of arrest, although 41% police personnel said that the procedures are always adhered to, 24% said that they are rarely or neverly adhered to. Kerala, where 94% said always, reported the highest compliance. On the use of third degree methods, 30% of police personnel said that these are justified towards the accused in serious crimes. Surprisingly, 9% justified this method even in petty offences. The victims of torture are, unfortunately, mostly from poor and marginalized communities. The groups generally targeted are Adivasis, Dalits, and Muslims, people who cannot read and write, are slum dwellers. Custodial dates showed discrepancies in figures furnished by different agencies. Thus, in the year 2020, the National Crime Records Bureau (NCRB) reported 76 cases, while the National Human Rights Commission reported 70 cases. The National Campaign Against Torture (NCAT)